Section 3 talks about condonation of remission of debt. So according to Article 1270, condonation or remission is essentially gratuitous and requires the acceptance by the obligor. It may be made expressly or impliedly. So gratuitous means something is done voluntary or for free without receiving anything in return. One and the other kind shall be subject to the rules which govern inofficious donations impliedly. So express condonation shall furthermore comply with the forms of condonation according to Article 1187. Condonation or remission is a mode of extinguishing an obligation, and also defined as an act of generosity where a creditor voluntarily gives up the right to collect a debt, either fully or partially without receiving anything in return. So it must be completely free, and if the creditor gets something in exchange, it turns into a different legal act. So dation in payment. If the creditor accepts something different instead of the original debt. So for example, si Lawrence kay nangutang og 10,000 pesos and instead of cash ang iyang ibayad, nag-offer siya og tablet nga same amount sa iyang gi-otang nga cash nga 10,000. So moto kibali ang dawaton sa creditor nga full payment sa iyang cash nga gi-utang. Novation. If the terms or condition of the debt change. So, for example, kay nangutang ko og 5,000. So, aga ko kay obligated ko nga mo bayad kausara. So, kay 5K man agahong giutang, dapat 5K pod nga buo ang ahong i-bayad. So, if ang creditor mo agree to change the terms, allowing me to pay monthly or installment instead, the original obligation is replaced with a new one. So, instead na kausara ko mo bayad, I was obligated to pay monthly or installments. Compromise. If the debt is disputed and both sides agree to settle with concession. So, for example, si Lawrence kay nangutang og 20,000 pesos and later on, iyang gi-claim nga ang iyang giutang kay 15,000 ra daw. So, to avoid legal battle, both sides agree for settlement or like na sila gisabutan duha nga amount nga maoy bayran. So, each side gives up something to reach an agreement. So, requisites or the condition or requirements of condonation or remission. So, there are 6. So, number 1, it must be gratuitous. So, means voluntary or for free. Number 2, it must be accepted by the debtor. Number 3, the obligation must be demandable. Number 4, the parties must have capacity. And the 5, the condonation must not be inofficious. So, kay not be inofficious man, it should be helpful or useful. And number 6 is, the condonation must comply with the forms of donation if it is an express condonation. So, express condonation is when a creditor clearly and explicitly forgives a debt, either in writing or verbally. So, extinguishment of obligations. So, according to Article 750, the donation may comprehend all the present property of the donor or part thereof, provided he reserves in full ownership or in usufruct sufficient means for the support of himself and of all relatives who at the time of the acceptance of the donation are by law entitled to be supported by the donor. So, without reservation, the reduced in petition of any person affected. So, according to Article 752, the provisions of Article 750, notwithstanding, no person may give or receive by way of donation more than he may give or receive by will. Forms of donation. So according to Article 748, the donation of a movable may be made or orally in writing. So an oral donation requires the simultaneous delivery of the thing or of the document representing the right donated. So if the value of the personal property donated exceeds 5,000 pesos, the donation and the acceptance shall be made in writing, and or otherwise, the donation shall be void or mawalan og epekto. So according to Article 749, in order that the donation of an immovable may be valid, it must be made in a public document specifying therein the property donated and the value of the charges which the donee must satisfy. So, para mavalid ang donation, dapat na ay legal writings or notarized documents present. The acceptance may be made in the same deed of donation or in a separate public document, but it shall not take effect unless it is done during the lifetime of the donor. So, ang recipient or ang gitagaan na ay gipang permahan to confirm nga iya gi-accept ang donation. So, there are three kinds of remission or condonation. So, number one is as to form. And there are two types of as to form. Letter A is express, when it is made in accordance with the formalities prescribed by law for donation. So, express is made by following legal formalities. Letter B is implied. So, implied when although it is not made in accordance with the formalities prescribed by law or for donations, it can be deduced from the acts of the obligee or the creditor. So, dili siya formally stated but can be inferred from the action sa obligee or the creditor. So, number two is as to extent. Also, there are two types of as to extent. Letter A is total, when the entire obligation is extinguished or nahuman na. And letter B is partial. It is partial when it refers only to the principal or to the accessory obligation or to an aspect thereof which affects the debtor. As for instance, solidarity. So, ang na-cover kay part rest obligation, dili ang whole. Like for example, ang principal or ang accessory obligation ra. And number three, as to constitution, and there are also two types of it. And letter A is inter vivos, or it refers to the which is constituted by agreement of the obligee and the obligor. So in which case, it partakes of the nature of the nation inter vivos. So, ang kaning inter vivos kay takes effect while the donor is alive, like the regular donation. So, ang letter B is mortis causa, which is the opposite of the inter vivos. So, ang mortis causa, it refers to which is constituted by last will or testament. So, effect running ang mortis causa once the donor is dead, or like for example, ang will sa usa ka tawo. Vis-a-vis counsel. In those recalcitrants, there could hardly be honest belief. So, it is when someone is forced or influenced into a stubborn or resistant position, it's difficult to claim that they genuinely believe in something. So, according to Article 1272, whenever the private document in which the debt appearing is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily unless the contrary is proved. So, for example, kay si Milavell nagpahuwam og kwarta ni Lawrence amounting to 5,000 pesos. So, after sa transaction, nagsuwat si Milavell og private document na nag-acknowledge na si Lawrence na ay utang nga kwarta. Then, afterwards, Milavell signed the document. After that, iyang gihatag ang document ni Lawrence for safekeeping. Para kung after that, kung pangitaan na ni Milavell si Lawrence sa iyang utang, na ikapakita si Lawrence nga document nga mora ni kibali ang utang nga iyang giutang ni Milavell, which is amounting to 5,000 pesos. So under Article 1272, so since nga ang document acknowledging the debt is in Lawrence's possession, it is presumed that Mila delivered the private document to him voluntarily. And according to Article 1271 to the new Civil Code, there is a prima facie presumption that when the creditor voluntarily delivered a private document evidencing a credit to the debtor, the former is renouncing his right of action against the latter for the collection of said credit. So, again, for example, ipahuwam ni Mila si Lawrence og 1,000 pesos. Then, nagsuwat og note si Mila nga nag-ingon nga si Lawrence na utang 1,000. Afterwards, gihatag ni Mila ang note ni Lawrence. So, the presumption kay tungod gihatag man ni Mila ang note ni Lawrence, okay ra para ni nga si Lawrence kibali ang mo hawid. So, which is also implied nga si Mila is in a sense of waiting para sa repayment ni Lawrence instead of pagdali-dali. So, in the present article, another prima facie presumption is created that whenever the private document in which the debt appears is found in the possession of the debtor, it shall be presumed that the creditor delivered it voluntarily. So, according to Article 1274, it is presumed that the accessory obligation of pledge has been emitted when the thing pledged after its delivery to the creditor is found the possession of the debtor or the third person who owns the thing. So, for example, si Lawrence nangutang og kwarta ni Mila. Then, gigamit ni Lawrence ang iyang tablet as collateral or pambayad sa iyang utang ni Mila. So, ang manag-iya sa temporary lease sa tablet is si Milavell for security nga mobayad si Lawrence sa iyang utang. So, the presumption is, if ang tablet gani nga naa sa care ni Mila, mabalik ni Lawrence, ang obligation to pay has been effectively established, or ang obligation nahuman na ni Lawrence, or ang obligation to pay is nahuman na. So, Article 2085, the following requisites are essential to the contract of pledge and mortgage. So, there are three kinds of it. And number one, that they be constituted to secure the fulfillment of a principal obligation. So, a pledge or mortgage is only valid if it guarantees a loan of or obligation. Number two, that the pledger or mortgagor be the absolute owner of the thing pledged or mortgaged. Only the rightful owner can pledge or mortgage a property. And lastly, that the persons constituting the pledge or mortgage have a free disposal of their property, and in the absence thereof, that they be legally authorized for the purpose, or the person must have the right to dispose of the property or be legally authorized. So, third persons who are not parties to the principal obligation may secure the latter by pledging or mortgaging their own property. So, according to Article 2093, in addition to the requisites prescribed in Article 2085, it is necessary, in order to constitute the contract of pledge, that the thing pledged be placed in the possession of the creditor or of a third person or party by common agreement. It is essential requisite that in a contract of pledge, the object of which is to be delivered to the possession of the creditor or of a third person by common agreement. Consequently, it is presumed that the accessory obligation of pledge has been condoned with the thing pledged after its delivery to the creditor, and also found in the possession of the debtor or of a third person who owns the thing.
So, Section 4, Confession or Merger of Rights. Section 4 of certain legal codes or property laws typically addresses the situation of confusion or merger rights. This concept plays a crucial role in determining when separate legal rights or interests might merge or become confused, effectively extinguishing or altering the original rights. The key ideas is that when two or more legal rights that were previously held separately came into hands of the same individuals or entity, the distinction between those rights may be lost, leading to a merger or confusion of rights. On Article 1275 speaks of confusion or merger of rights. It states that confusion or merger of rights is the meeting in one person of the qualities and obligee and obligor with respect to the same obligation. The characters of the creditors and the debtor are mixed in the same person, since it is nonsensical for the said person to push and pursue a claim against his own self. The merger results in the extinguishment of the obligation. For example, if a person who owes money to another person subsequently inherits the creditor's debt, the original obligation ceases due to the merger of the debtor and the creditor rules into one person. On the next article, the Article 1276 of the Civil Code defines the effect of the confusion of the merger of rights. It states that when the rules of the creditor and the debtor are merged into the same person, the obligation is extinguished. This occurs automatically, as it is legally impossible for a person to owe a debt to themselves. However, the article also notes that this rule does not apply to obligation that involves inalienable rights or family-related duties, which may not be extinguished by the merger of rights. For example, if a person A owes money to another person B, if a person A inherits the rights and claims of person B, the rules of the creditor and debtor merge in person A. As a result, the debt is extinguished because person A now holds both the right and the obligation, effectively cancelling the debt. Lastly, Article 1277 outlines the condition which confuse the merger may be limited or not applicable. Specifically, it emphasizes that certain obligations may survive despite merger if they are personal or family in nature. This provision aims to prevent the elimination of responsibilities that have the public policy or personal character, ensuring that essential duties are not undone merely by merging of rights. In conclusion of all of this, the principle of confusion or merger of rights as articulated in Articles 12755 up to Article 1277 of the Civil Code serves an important function of legal system by ensuring that obligations are extinguished when rules of creditors and debtors merge into one. The legal framework takes into account the practical realities and inheritance of debt management while protecting essential personal rights that may not be subjected to this principle. It is fundamental aspects of the civil law that balances the end of the obligation with the ongoing protection of the key rights.
So Section 5 talks about compensation. So Article 1278 states that compensation shall take place when two persons on their own right are creditors and debtors of each other. So compensation happens when two people owe each other money and their debts cancel out to the extent that they are equal. So instead of paying each other separately, they can simply reduce what they owe by the matching amount. So there are different kinds of compensation. Number one is by its effect or extent. It includes total and partial. So total, this is when both obligations are of the same amount and are entirely extinguished. So an example is, if si Lawrence naiutang ni Milavell nga 500 pesos and si Milavell na po'y utang nga 500 pesos ni Lawrence. So ang mahitabo is that they can cancel out both utang. So makwits na silang duha. So that is what total means. And the second one is partial. So this is when the two obligations are of different amounts and a balance remain. So an example is, si Alice naiutang ni Bob nga 1,000 pesos and si Bob naapoy utang ni Alice nga 700 pesos. So instead of both making separate payments, compensation applies automatically. So, ang 700 pesos cancels out on both sides, leaving Alice still owing Bob 300 pesos. So, since the debts were different amounts, compensation was partial. So, and Alice still has to pay the remaining balance, which is 300 pesos. So, the second one is by its cause or origin. So, it includes legal, conventional or voluntary, judicial, and facultative. So the legal, this is when it takes place by operation of law when all the requisites are present without even the knowledge of the parties. So same when it's just a partial. Conventional or voluntary, so this is when it takes place by agreement of both parties. So from the word agreement, same is total but it needs agreement laman both sides. So judicial is when it takes place by order from a court in litigation. So same when it's just a partial, but it involves court or judge. And the last one is facultative. So when it can be set up only by one of the parties. So only one can decide if musugot ba siya nga separate nga payment or partially. Yeah. And that's versus claim. So what is that? So that is an amount actually ascertained. So utang is a specific amount of money that one party legally owes to another. And on the other hand, claim is a debt in embryo. So it is a debt that has not yet been fully recognized or settled. So an example is a pregnant woman. So ang claim mo is siya ang process nga ang bata napasitiyan. And then, ang debts, mo na ang bata itself, kanang nabuhi ng bata. So, that is the explanation of debts and claims. Yeah. So, Article 1279. So, in order that compensation may be proper, it is necessary, number one, that each of the obligors can be bound principally and that he be, at the same time, a principal creditor of the other. The second one is that both debts consist in a sum of money, or if the things due are consumable, they be of the same kind and also of the same quality if the latter has been stated. The third one is that two debts be due. The fourth one is that they be liquidated and demandable. And the last one is that over neither of them there be any retention or controversy commenced by a third person and communicated in due time to the debtor. So Article 1280, notwithstanding the provisions of the preceding article, the guarantor must set up compensation as regards with the creditor may owe the principal debtor. So, even though the previous rule applies, a guarantor can use compensation of the creditor also owes money to the principal debtor. So this means that the guarantor can reduce or cancel the guaranteed debt based on what the creditor owes the main debtor. So that is the meaning of Article 1280. In Article 1281, compensation may be total or partial. So this is already discussed in Article 1278. So when the two debts are of the same amount, there is a total compensation. So compensation is total if both debts are equal. So it may cancel out completely, like makwit na dun sila kay same man og amount ang ilang mga utang. So if the debts are different, so only the smaller amount is cancelled, so which leaves a partial balance.
Now going on with the Article 1282, the parties may agree upon the compensation of debts which are not yet due. So, if a person accepts that compensation or offsetting debts will not apply in a certain case, or they cannot later demand it. Now we have the legal compensation versus the conventional compensation. So, legal compensation, it takes place by operation of law when all the requisites are present, as opposed to conventional compensation, which takes place when the parties agree to compensate their mutual obligations even in the absence of some requisites. So to be more simple, ang legal compensation, it happens automatically when two people owe each other and all legal requirements are met. Now we have the conventional compensation. So on conventional compensation, we recognize the concept of conventional compensation defined as occurring when the parties agree to compensate their mutual obligations even if some requisite is lacking, such as that provided in Article 1282. So on conventional compensation, it is intended to eliminate or overcome obstacles which prevent ipso jure extinguishments of their obligations. So when we say ipso jure, it is by the law itself or by the operation of law. Article 1283, if one of the parties who is sued over an obligation has a claim for damages against the other, the former may set it off by providing his right to said damages and the amount thereof. So ang pasabot sa 1283, compensation does not apply if one of the debts is about something that cannot be taken or given up legally. Now we have Article 1284. When one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. So in Article 1284, if the debts are not equal in amount, compensation only applies to the part that matches. The rest must be paid. Now, the Article 1285, the debtor who has consented to the assignment of rights made by a creditor in favor of third person cannot set up against the assignee the compensation of which would pertain to him against the assigner, unless the assigner was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. So on Article 1285, compensation is only between two people who owe each other. It cannot involve a third person. Now, what is assignment of rights? So, an assignment of rights, it is the transfer of rights, especially contractual rights, from one party to another. Effects of assignments of rights. So, number one, if the debtor consented to the assignment of rights made by a creditor in favor of a third person, he cannot set up against the assignee the compensation which pertains to him against the assigner. The second one, if the debtor consented to the assignment of rights made by a creditor in favor of a third person, and he reserved his right to the compensation, then he can set up against the assignee the compensation which pertained to him against the assigner. So I will provide you an example for that. So, ang sabuane, si Ana, which is a creditor, is owed 10,000 pesos by Ben. So, si Ben mao niya ang debtor. However, Ana also owes Ben 4,000 pesos. So, si Ana, she decided to assign her right to collect the 10,000 from Ben to Charlie. So, si Charlie, mao niya ang assignee. So, Ben agrees to this assignment but tells them that he reserves his right to compensation. Later, when Charlie, which is the assignee, demands the full 10,000 pesos from Ben, Ben sets up his right for compensation and deducts the 4,000 pesos that Anna owed him. As a result, Ben only pays Charlie 6,000 pesos instead of the full 10,000 pesos. This follows the legal principle that if the debtor receives the right to compensation, he can still offset the amount owed to him against the assigner.
So the third effect of assignment of rights is if the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also later ones until he had knowledge of the assignment. So again, I will be providing you an example for this. So see David, which is the creditor, is owed 8,000 pesos by Eric, which is the debtor. So at the same time, si David po, he also owes Eric 3,000 pesos. So without informing Eric, David assigns his right to collect the 8,000 pesos to Frank. Si Frank maoni ang assignee. So before Eric learns about the assignments, David borrows another 2,000 pesos from him. So later, when Frank, which is the assignee, demands the full 8,000 pesos, so Eric sets up his right to compensation for both the 3,000 pesos and the 2,000 pesos, which in total 5,000. Since he only learned about the assignment later, as a result, Eric only pays Frank 3,000 pesos instead of the 8,000 pesos. Now going on, Article 1286 states that compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. Article 1287 states that compensation shall not be proper when one of the debts arises from a depositum or from the obligations of a depositary or of a bailey in commodum. So to be more simple, in Article 1287, compensation cannot be used for debts related to deposits, loans, for temporary use, or claims for support. Article 1288 states, neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. So on Article 1288, a person who wrongfully takes something, such as a thief, cannot use compensation as an excuse not to return it. Now we have the debts which cannot be compensated. So the first one, debts arising from a contract of depositum. So compensation is not allowed if one debt comes from a deposit, where someone keeps another person's property for safekeeping. Second one is debts arising from a contract or commodum. So compensation is not allowed if one debt comes from a commodum, where something is borrowed for temporary use and must be returned. Third one is claims for support due by gratuitous title. So compensation cannot be used against a claim for free support, which includes basic needs and cannot be given or transferred. The fourth one is one of the debts consists in civil liability arising from a penal offense. So meaning, debts cannot be compensated if one of the debts consists in civil liability arising from a penal offense. Okay, going on, we have the Article 1289. So if a person should have against him several debts which are susceptible of compensation, the rules on the application of payment shall apply to the order of the compensation. So to be more simple, on Article 1289, once compensation happens, it cancels out the debts as if they were paid now. So Article 1290 states that when all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. So again, to be more simple, Article 1290 is all about compensation takes effect from the moment both debts exist and met all legal requirements, even if it is declared later.
So Section 6, Novation. Novation comes from the Roman Republic that meant the substitution of a debt or delegation of a new contract. In Binisaya, mao ni ang pag-usab or pagbago sa usa ka nag-exist na kontrata. Now in Article 1291, gibutang diha nga ang obligasyon mausog or magbag-o sa ingani nga pamagi. Number 1, changing their object or principal conditions. Like for example, si Simon obligado nga mohatag og sakyanan adto ni Pedro. Karon nagkasinabot sila na instead og sakyanan ang ihatag, napuo ka aircon ang i-deliver. So mao ni ang pasabot sa number 1. So number 2, substituting the person of the debtor. Diriya gipasabot ang pag-agreed on both parties sa pagbaylo. For example, ako ang naiutang, then misugot agahong giutangan nga agahong mama na lang ang mo take sa akong place. So take note nga misugot ang imong giutangan aron mabalid ni nga pagbago. So number 3, subrogating a third person in the rights of a creditor. So ang example ani is if ang agreement sa duha ka parties ni Simon nga mo deliver si og napo kayrkon adto ni Dan, instead si Simon mo deliver og sakyanan adtong Ben. Then naay mixed novation nga nahitabo kay ang object og ang creditor kay nausog man. So next topic, what is the consideration in contract of novation? So mao ni ang pagbaylo og value or benefits sa duha ka parties. Agreement ni siya where ang obligations sa usa ka party ibalhin niya sa usa ka party with of course consent sa original parties. Aron mabalid ni nga novation, each parties daw na ay bagong agreement of each parties na ay madawat nga consideration or something valuable aron matransfer ang rights o duties. Aron dali masabtan, kumpanya A magpasa sa iyang kontrata ngadto kang kumpanya B. Kumpanya B magpasabot nga tumanon ang mga kondisyon sa kontrata apan maghatag kini og bayad or serbisyo ngadto kang kumpanya A. Ang konsiderasyon ini mao ang bayad o serbisyo nga ihatag ni kumpanya B kang kumpanya A nga mahimo sa novation nga legal o balido. So, what is novation? Mao ni ang legal na proseso sa usa ka party nga mag-usab sa iyang mga rights o obligasyon. So, mao ni ato mga gipang topic, istorya ganina sa ato mga niyaging topic. So, is there a form required in novation? Walay form nga required aron mavalid ang novation, pero need gyapon ang contract or kasabutan para sa bag-o na termino or obligasyon. Ang kinahanglan ra formal na papel o nga tuwa dito ang gikasabutan o ang pinakaimportante ang pirma sa tanang partido. O novation is not presumed. Nagsabot ni nga dilematic nga mahitabo ang novation base sa lihok ra sa mga partido. Kinahanglan jud nga naay valid nga kasabutan aron maalisdan ang daan nga gikasabutan. Kung way kasabutan nahitabo, why novation nga mahitabo o nahitabo. So kinds of novation na punta. Number 1, as to subject. A, real objective. Mao ni ang pag-alilis sa daan nga gikasabutan o obligasyon. O bayloan ni og bag-o nga kasabutan o obligasyon. Example, si X obligado na mo deliver og laptop ni Y. Nakaudyo na nilang duha nga dili na lang laptop ang deliver kundi ang duha ka specific na phone na lang. So, mawa na to ang daan na obligasyon kay naamay bag-o sa ilang ikasabutan na obligasyon. So, mao to ang real objective. So, letter B, personal or subjective. So, mao ni ang sitwasyon na ang usa ka obligasyon ipasa pero dili magbag-o ang obligasyon o ang kontrata. So, naapod ni upat ka requisites. Number 1, ang daan na obligasyon. Number 2, ang agreement sa mga partido aning mga bag-ong contract. Number 3, ang pagwala sa daan na obligasyon. O ang number 4, ang paghimo og bag-ong obligasyon. So, example ini, si X obligado na muhatag og laptop adto ni Y. Pero, nakasabutan ni na X ug Y nga si Z ang ibaylo ni X. Og diha, mavalid nga si Z na ang mubaylo ni X. So, mo to ang personal or subjective. So, letter C, mixed. Diri mo ni ang sitwasyon nga ang mga partido o ang mga obligasyon o kontrata pareho magpag-o. Mahitabo kini kung ang usa ka partido mapulihan og sabay nga mausap ang kauban nga bahin sa kontrata sama sa mga obligasyon o termino. Example, si kumpanya A o B naay kontrata pero gipulihan ni kumpanya C si A o diha na giusob ang obligasyon o kontrata ni B. So mao to'y pasabot sa MIS. So as to constitution, letter A, express or explicit declaration kay usa ka klaro og diretsong pahayag nga gihimo sa usa ka partido. Bisan pasabot sa sinulat o oral nga nagpakita sa ilang intensyon o pag-uyon. So bali matik diretso na jud nga ning sugot sa ato nga kontrata or obligasyon. So, letter B, implied or material incompatibility, kay usa ka kondisyon nga wala diretso nga gipahayag apan gina-assume o gina-expect base sa kinaiya sa kontrata o sitwasyon. Mahitabo kini kung ang mga bahin sa kontrata dili magkatugma o magkasumpaki nga maghimo nga imposible nga magpadayon sa kasunduan sa parehong mga termino. So mao ni kasagaran og dili magkasinugtanay sa kontrata, mao ni ang implied or material incompatibility. So test of incompatibility gigamit ni aron ma-review didto kung adunay bahin sa kontrata nga nagkasumpaki na aron dili mahimo ang usang kontrata. Example ini is kung ang kontrata nagkinahanglan og buhat nga dili kaya buhaton sa usa ka partido, kini mahimo usa ka test of incompatibility. So mo to siya. So ang atong number 3, as to extent or effect, letter A, total or extinctive, ang may tabuan ay mapulihan ang daan ng obligasyon tungod kay sa mawala na ang daang gikasabutan o alisda na pod ni og bag-o. Naay dual functions sa instinctive novation, ang pagwa sa daan nga obligasyon ug ang paghimo sa og bag-o. Letter B, partial or modifactory. So diri naalang bag-ohon sa ubang part sa ilang kontrata pero dili siya alisdan, tanan naalang bag-ohon or i-update sa kontrata. So mora to sa akong topic. I'm Ian M. Dulla, base A1C.
Going on, the total novation and the partial novation. The partial novation occurs when only some principles, condition are modified, but the main obligation still remain. For example, si Ana nangutang og 500 kang ben. Nga dapat niya baryan karong adlaw, nagkasabot sila nga si Ana magbayad na lang sunod semana. That's one example of partial novation. And the total novation happens when the old obligation is completely extinguished and replaced by a new one. For example, si Ana na nakautang og 500 kang ben. Imbis bayaran, nagkasabot sila nga si Ana mupuli sa utang pinaagi sa paghatag og bugas na worth sa iyang giutang 500. And there's two origin of novation: the legal and conventional. Legal novation, which takes place by operating of law, and the conventional is novation, which takes place by stipulate of the parties. Article 1292. In order that an obligation may be extinguished by another which substitute the same, it is imperative that it be so declared in unequivocal terms, or that the old and the new obligations be on every points incompatible with each other. It means that in order to replace an existing obligation with a new one, the two obligations must be such that fulfilling one would make the other impossible to be fulfilled. Article 1293. Novation, which consists in substituting a new debtor in the place of the original one, may be made even without the knowledge or against the will of the latter, but not without the consent of the creditor. Payments by the new debtor gives them the rights mentioned in Article 1236 and 1237. The kinds of personal novation. First is substitution, and second is subrogation. Substitution means that the person of the debtor And the subrogation, it means a third person in the rights of the creditor. Kind of substitution. The expromission, the initiative for the change does not come from the debtor and may even be made without his knowledge. Since a third person would substitute for the original debtor and assume the obligation, his consent, and that of the creditor would be required.
Predator.
Creditor lagi.
Creditor.
Creditor would be required. Delegation. Substitution of the person of the debtor may be effected by delegation, meaning the debtor offers and the creditor accepts. A third person who consents to the substitution and assume the obligation, thereby releasing the original debtor from the obligation. Here, the intervention of the consent of all parties thereto would be necessary. Article 1294. If the substitution is without the knowledge or against the will of the debtor, the new debtor, insolvency, or non-fulfillment of the obligation shall not give rise to any liability on the part of the original debtor. It means that if a debtor replaces himself without a new debtor without the original debtor's knowledge or against their will, the original debtor is not responsible if the new debtor becomes insolvent or fail to fulfill the obligation. Article 1295. The insolvency of the new debtor has been proposed by the original debtor and accepted by the creditor shall not revive the action of the latter against the original obligor, except when said insolvency was already existing and of a public knowledge, or known to the debtor when he delegates his debt. It means that if the original debtor proposed a new debtor and the creditor agrees, the original debtor is not liable if the new debtor becomes insolvent, unless the insolvency was known or publicly known before the original debtor made the substitution. Article 1296. When the principal obligation is extinguished in consequence of an novation, accessories obligations may subsist only insofar as they may benefit third person who did not give their consent. When a novation extinguishes the original obligation, any relative accessories obligation can still exist if they benefit third parties who did not consent to the novation.
Now we have the chapter 4, which is extinguishment of obligations. So we have the exception. So accessory obligations may subsist only insofar as they may benefit third persons who did not give their consent. Now we have the Article 1297. So if the new obligation is void, the original one shall subsist, unless the parties intended that the former relation should be extinguished in any event. So we have the effect of novation where the new obligation is void. So we have the general rule. If the new obligation obligation is void, the original one shall subsist. Take note that the first requisite of the valid novation is that there must be a previous valid obligation, but now consider an exception. So an exception is the parties intended that the former relationship be extinguished in any event. Now we have the Article 1298. The novation is void if the original obligation was void, except when annulment may be claimed only by the debtor or when ratification validates acts which are voidable. So we have the effect of novation where the old obligation is void. So again, na ay general rule. So ang general rule, the novation is void if the original obligation was void. This is because a void obligation is inexistent. Again, take note that the first requisite of the valid novation is that there must be a previous valid obligation. So I will provide you an example now. So, for example, si X agreed to give Y a smuggled car, but since smuggling is illegal, this agreement is not valid. Later, they decided that instead of giving the car, X would give Y 500,000 pesos instead. However, this new agreement is also invalid because it is based on a legal deal in the first place. So, an exception, when annulment may be claimed only by the debtor or when ratification validates acts which are voidable. So, voidable obligations are binding unless they are annulled by proper action in court. So, they are susceptible of ratification. So, ratification cleanses the contract from all its defects from the moment it was constituted. So, moving on, Article 1299, if the original obligation was subject to a suspensive or resolutory condition, the new obligation shall be under the same condition unless it is otherwise stipulated. So I will provide you an example for this one. So si Anna, she agrees to buy Ben's car only if she gets approved for a loan or a suspensive condition. If this obligation is later changed to a new agreement, like a different payment plan, the loan approval conditions still applies unless they agree otherwise.
Now, Article 1300, subrogation of a third person in the rights of the creditor is either legal or conventional. So the former is not presumed except in cases expressly mentioned in this code. The latter must be clearly established in order that it may take effect. So there must be an express intention to novate, and a must novant novation is never presumed. So Article 1300 of the Civil Code provides inter alia that conventional subrogation must be clearly established in order that it may take effect. So subrogation, by definition, is a transfer of all the rights of the creditor to a third person who substitutes him in all his rights. So naate kinds of subrogation, no? The first one is conventional subrogation and the legal subrogation. So ang conventional subrogation, that which takes place by agreement of parties. Meanwhile, ang legal subrogation naman, it takes place without agreement but by operation of law because of certain acts. So conventional subrogation, it is the transfer of all the rights of the creditor to him or to a third person who substitutes him in all his rights, which takes place by agreement of parties. Now, the debtor's consent is necessary. So, subrogation extinguishes an obligation and gives rise to a new one. So, the nullity of an old obligation may be cured by subrogation such that the new obligation will be perfectly valid. So, we have the assignment of rights. So, assignment of rights, this is an agreement by virtue which the owner of the credit, known as the assigner, by a legal cause such as sale, datation in payment of exchange, or donation, and without need of the debtor's consent. So transfers of credit and its accessory rights to another, known as the assignee, who acquires the power to enforce it, to the same extent as the assigner could have enforced it against the debtor. The debtor's consent is not required. So assignment refers to the same right which passes from one person to another. So the nullity of an obligation is not remedied by the assignment of the creditor's right to another. So even if the debtors have not been notified, but came to know of the assignment by whatever means, the debtor is bound by it.
Now we have Article 1301. Conventional subrogation of a third person requires the consent of the original parties and of the third person. Article 1302. It is presumed that there is legal subrogation. So 1. When a creditor pays another creditor who is preferred, even without the debtor's knowledge. 2. When a third person, not interested in the obligation, pays with the express or tacit approval of the debtor. And lastly, which is 3, when, even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter's share. So what exactly is legal subrogation? So legal subrogation is that which takes place without agreement but by operation of law because of certain acts. That is a subrogation referred to in Article 1302. So I will provide you an example. So an example is John's car is damaged in an accident caused by Mike. So John's insurance company pays for the repairs. Later, the insurance company sues Mike to recover the money it paid. Here, the insurance company steps into John's shoes to claim damages from Mike. This is legal subrogation. Now we have Article 1303. Subrogation transfers to the person subrogated to the credit with all the rights thereto appertaining, either against the debtor or against third person, be they guarantors or possessors of subject to stipulation and a conventional subrogation. So again, I will provide you an example. So Lisa owes Mark $1,000. So Emma pays Mark on Lisa's behalf. Now Emma takes Mark's place as the new creditor and can demand payment from Lisa or any guarantor or mortgage holder. So Article 1304, a creditor to whom partial payment has been made may exercise his right for the remainder, and he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. Again, example, Lisa owes Mark $1,000, Emma pays Mark $600. Mark can still claim the remaining $400 from Lisa and has priority over Emma in collecting the debt.